Okay, looks like we have everybody here. Mr. White, you are for the appellant. Do you wish to reserve time for rebuttal?
3 minutes, please.
You got it. Go ahead, sir.
If it please the court, counsel, my name is Roger White. I represent the appellant in this matter, Muto Health Systems, LLC, doing business as Brian Muto, DC, as assignee of Donovan Boykins, First Progressive Select. They were the plaintiff at the lower court. We are here asking this court to reverse the granting of summary judgment in favor of the appellee and denying summary judgment in favor of the appellant on a very unique and specific issue. By way of brief background, this is an action for PIP benefits pursuant to an automobile accident that occurred on January 20th, 2016. Donovan Boykins.
The issue is, the primary issue in this case is Dr. Muto had his license suspended in November, which was a couple of months before the treatments occurred. He didn't hire his license was suspended. He didn't do anything to comply with the Healthcare Clinic Act and get a medical director in there. The statute is clear that the insurer is not required to reimburse unless the provider meets the criteria in the statute, which is a licensed physician or Healthcare Clinic Act compliant entity. That we don't have that here.
Well, Your Honor, respectfully, we don't need a medical director and we don't fall under the Healthcare Clinic Act.
Well, I know that didn't happen, but at the time the treatment was provided, your client his license was not intact. He was suspended. And the statute is clear that the only people eligible for reimbursement are licensed providers. And the legislature spent a lot of time writing that up in 2013. So
absolutely.
How do we tell me how we're going to ignore that statutory text?
Yes, Your Honor, it's an excellent question. The fact is, Your Honor, despite the fact that there was a suspension of his license, Dr. Muto remained a licensed practicing physician pursuant to every definition that can be found in Florida law and administrative code. Specifically, in sections 458 and 460 of Florida statutes, the definitions of a physician means a person who is licensed to practice medicine in this state. Pursuant to 460.
A suspended license is licensed.
Yes, a license suspended is still a license possessed. The only thing that was suspended, the only thing that Dr. Muto lost at the time the emergency suspension order was levied, November 23rd of 2015, was his right to practice.
See, it's interesting, Mr. White, that actually kind of, you charge the trial court with the error of layering on extra verbiage in the statute. As I read your argument, I couldn't help but think that your argument too has arguably a measure of that, insofar as you are taking the term "is licensed to practice" to mean, rather than the obvious man on the street connotation it would have, which is you are allowed to practice, rather that it means possesses a license. And that's not the term that the legislature used there. So how do you get from "is licensed to practice" to possesses a license?
Well, the fact remains he is licensed to practice. Those practicing privileges.
No, he's not. He can't practice. You've excised "to practice" in your argument and just made it into "do you possess a license?"
I appreciate the position, and that was the tact that was taken by the defendant at the lower court. But let me jump ahead to I believe my language is irrelevant. I believe the appellee's language is irrelevant. What I believe is most relevant for this court to consider is the language utilized by the governing board, by the Florida Chiropractic Medicine Medical Board, when it issued its administrative order from March 4th, 2016. You can find that on the record, PDF 309. Specifically, what the chiropractic board found at that time, and in its listing of the relevant facts of that case, was that Dr. Muto was in fact
Right. Well, let me cut to the chase. Sure. What that's saying is there is a license to suspend. Yes, it's the introductory facts. So you're saying in the introductory facts, the administrative body said, hey, let's set the table here. This guy has a license that we can suspend.
Well, more importantly, when they were talking,
that's supposed to guide our interpretation of what license to practice means.
Certainly, because the stipulated facts, again, paragraph 1, at all times.
Wasn't that administrative body just differentiating it from someone, say, who did not have a license to suspend, like a Georgia license or something like that?
Well, again, that would go to the position taken by the appellant that the only language contained in the statutes is that the individual be a licensed physician in the state of Florida.
Licensed to practice
Well,
in-
excuse me, there's another part of this statute that is critical here. And it is 6277365D, which precludes the insurer from reimbursing to a person or entity that performed services without possessing a valid license. A suspended license is not a valid license.
I respectfully disagree. There's no language to indicate in the Florida statutes that a suspended license is not a valid license. The language that, again,
But your argument requires us to view the text of this statute in sort of a state of suspended disbelief regarding, pun intended, regarding the status of this guy's ability to practice medicine and render treatment, which under the statutory text he didn't have. And
if I may, I understand the court's position, but we are not discussing here today whether Dr. Muto could perform medical services. Clearly, he could not. What we're discussing is whether he satisfied the requirements of 627736 and that his medical facility, which was the entity billing for the services rendered by another physician, was lawfully rendering service because it was wholly owned by a licensed physician. A licensed physician
this is the problem. He wasn't a licensed physician within the common man reading of the text of this statute. He couldn't practice medicine.
But his license
had been emergency suspended.
He remained a licensed physician regardless of his inability to
Let's
practice
talk about
medicine.
another word then, suspension.
Yes. Okay.
That means to take away, doesn't it?
Well, specifically that those words are defined for us. And the definition specifically is pursuant to the Federation of State and Medical Boards. A suspension is a disciplinary action taken by a state medical board ordering a licensee to temporarily cease the practice of medicine. Even in the definition contained therein, he's still called a licensee.
But he also, in your definition, he is unable to practice medicine during the period of suspension.
But again, his ability to practice medicine is irrelevant whether the services rendered at Muto Health Systems LLC were lawful. And the question
let me comment this another way. If Dr. Muto, hypothetically, he could have gotten a medical director and taken the steps to comply with the Healthcare Clinic Act, despite his license being suspended. And he had another physician working there, so he could have turned that physician presumably into a medical director. He didn't do that. And to my read of this record, he just got caught by not having done that. Because your argument would be fine if he had procured the services of a medical director and complied with the Healthcare Clinic Act.
Well, I'd have no argument because we wouldn't be here. But the reality is you can't instantly assign a medical director. It's a procedure contained in the ACCA statute that is a lengthy one. There's an application process, there's a review, and then there's an acceptance of that medical record. It's not something that can happen by assignment. Dr. Muto had no ability to look at Timothy Johnson and said, I'm going to make you the medical director, and starting tomorrow, we're going to continue delivering medical services exempt from the HCCCA requirement. But again, the reading of the statute, there is a distinction between suspension and revocation. If his license being suspended as of November 23rd meant he had no license, which seems to be the position taken here, then why is there a distinction in the penalties outlined under Florida law between?
Aren't we then talking about the administrative, there's a due process issue associated with revocation. So there's a two-step. You can go through an emergency suspension, and then after because an emergency suspension happens with little or no due process, then the provider, in this case the physician, would have the opportunity to argue against the suspension, failing which the license will be revoked. But that's different. That status for purposes of the administrative proceeding with respect to the license is different than what the physician's status is a licensed provider within the meaning of the PIP statute.
I respectfully disagree, Your Honor, because again, we only have the Florida statutes to serve as our guide here. The definitions contained therein indicate nothing in the way of unencumbered, not clouded, clear and free to practice medicine. All they say is that you have to be currently licensed in the state of Florida. And to the extent
So,
that they
Mr.
do,
White, if
Yes.
if I went up to just an ordinary person on the street and said, I am a licensed attorney, but my license had been suspended and I did, for misappropriating client funds, and I did, would you say that I had made a truthful representation, a fully truthful representation?
well, I don't know that again, you're suggesting if you told somebody you're a licensed attorney and yet you had a suspension and they were unaware of that, would you be making a truthful representation?
Yeah, that's what I'm asking. Is that a
It would be
truthful
a-
representation?
It would be an incomplete representation. You still have a license. There's no question about
And you know
that.
how we charge, you know how we charge juries about weighing credibility and deciding what is true and what is not true, that an incomplete statement can be factually incorrect.
Of
right?
course, and I'm not here to suggest that your representation would be wholly truthful, but that's not what happened in this case. Dr. Muto didn't try to pull the wool over anybody's eyes.
No, I'm not suggesting he did, but the interpretation that is being advocated here
Mhm.
necessarily assumes that, right? Because again, it goes back to the idea that possessing an unrevoked license is all it takes to be a licensed chiropractor.
Again, for the limited purpose, Your Honors, of ownership of a medical clinic, which is exempt from the HCCA requirements of clinic registration and medical director appointment. That's the only narrow issue here. And I would point, Your Honors, we know that an emergency suspension was issued on November 23rd, 2015. In the very sections of the administrative code of the statutes that the appellee relies on in regards to medical director, they talk about the penalties for failing to maintain a medical director. The failure to maintain a medical director is an immediate order to cease operations of that clinic until they come in line with the statutory requirements. There is absolutely no prohibition. There was nothing to have prevented ACA at that time because Dr. Muto is now on the radar. He's well known now to have had a suspended license. What could have happened the day he was suspended, because it would be then known this previously exempt clinic now doesn't have a medical director that, according to the argument of the appellee, is now required, could have immediately suspended the operations of that medical facility. They did not. Even after the administrative hearings were begun in December, the complaint was filed in December. No board, no agency shut down the operation of this medical facility. There is a reason. And Judge LaBritte referenced it before. There are due process considerations here. The point of the medical director statute, the history of it, we need somebody, when a lay person owns a medical facility, to oversee the operations of that facility, because lay person don't always know the ins and outs of the medical procedure or the medical profession, what is required, record keeping, billing, etc. So you have, as a guarantee to the public, a medical director appointed. The reason
Well, the medical director serves more than an administrative
course,
function. The reason you have a physician as a medical director is for clinical protocols.
You're 100% right. And to the extent that that is true, that is why the medical director statute, unlike all the other statutes pertaining to the definition of a physician, includes the word unencumbered as it relates to the license. Had the legislature intended that very same requirement to apply to a physician who owns his own facility and is thereby exempt from the ACA requirement of the appointing of a medical director, is because a trained, licensed doctor who owns his own medical facility, even while his practicing privileges are suspended, still has the understanding, the knowledge, the experience that comes along with that licensure to assure that the operations of those clinics are running according to the
At least
law.
the financial operations, but the reason his license was suspended was for clinical reasons.
No, the reasons his license was suspended were because of crimes he committed sometime earlier. separate and apart from the practice of his profession. They happen to touch upon areas that involve his profession, but they were not related to the conducting of his business, just for the clarity of the record. The point I'm making otherwise is you can't add these words to the statutes. We are not at liberty to change the clear and plain meaning of these statutes. And they are just that. They were clear and unambiguous. And if you read them, there's a distinction between the requirements of a medical director and the requirements of a physician. And the lack of an encumbrance is not one of them, or is one of them. The fact of the matter is, the appellee in their brief made hay to the extent that it seems illogical, almost absurd, to require a medical director to have an unencumbered license, but not a physician. And I think Judge LaBritte touched on it very succinctly when you're talking about the responsibilities of a medical director, where a layperson owns a facility. There will be some clinical analysis involved. There will be some doctoring that needs to be done, and a licensure, unencumbered, active, and clear, is required. For the purposes of the intention of ACA and the requirement of medical director, Dr. Muto still remained a licensed doctor. He owned his medical facility. Most importantly, that know-how, that knowledge, that experience that comes along with being a licensed medical professional still existed. His clinic, now manned by another physician, is running. They don't come in and shut down businesses instantly. As the Supreme Court of Florida has held, the right to practice medicine is in fact a property right protected by the Due Process Clause of the Constitution.
I know you're not going to fall on your sword here, but there is a difference between the status of your client's license relative to ACA, suspension to revocation, and that process. There's a difference from that context to what the PIP statute requires to be eligible for reimbursement. His due process status with regard to suspension, revocation is not part of what an insurer is required to verify before issuing payment. And to put it differently, and again, I understand your position and that you have to argue it, but were Progressive to have reimbursed your client in the situation that it was in without a license, the next thing that's going to happen to Progressive is when they get the next provider that comes in is going to accuse them of making a gratuitous payment to your client because he wasn't eligible to receive the payment that was made. So Progressive isn't in the business of working through your client's license status. It's in the business of trying to pay the providers the way the PIP statute says it has to. And if it doesn't do that, then it gets exposed for extra contractual liability. Can you help me out with that?
Certainly. That again falls on the premise that he did not have a license. And Your Honor, all I can do is consistently point to the Florida statutes, which are clear and unambiguous. He had an active license. The Florida Chiropractic Board, in describing his status.
So you would have Progressive's billing processor, whoever handles their claims processing, would not be entitled to rely on the express language of the statute that says licensed physician eligible to practice medicine, the words we've already talked about. You would charge them with the responsibility to go learn the overlay in the due process context associated with your client's license proceeding by ACA and apply that here, and then expect all the subsequent providers that are lined up waiting for them to exhaust to intuit the status of his license based on the disciplinary proceeding.
Well, as they are the only insurer took this position, I can assure you that what they have to do to make their position tenable is establish that he no longer has a license. All I can offer to the court, and I can point to the plain language of the statute, I can point to the language of the Chiropractic Board, I can point to the distinction between a suspension and a revocation and various penalties for these type of violations. But what I can tell you is, at the time treatment was administered in January and February, he had an active license. His practicing privileges pursuant to that license were suspended. If he administered any care, then that's not.
I'm not talking about that for a second. The license itself is suspended. It says, I mean, you said, and I said it, you said in your brief that it was his practicing privileges that were suspended. But if you want to talk about the language, it does say that it is the license that is suspended.
Yes, but actually it specifically says his practicing privileges are suspended. And as I gave you the definition earlier in the argument,
No,
a suspension is,
it also talks about suspending the license.
but if you look at the definition of what suspension means, it's the temporary cessation of the right to practice medicine. It has nothing to do with the removal of the license.
Real stop. That is not that part where you're just saying, where did you get that definition from?
Again, as I read to the court earlier, and I'll cite it again, the Federation of State Medical Boards,
All right.
which Florida subscribes
Let's
to.
not talk about the Federation of State, whatever. Let's talk about the statute talks about suspending a license.
Okay,
I'm
the
just
suspension of a, the suspension of a,
shattering. It's just that you keep saying, or you did in your brief, and you said it again, that it was merely his practicing privileges that were suspended. No, the statutory language talks about suspending the license. So we're talking about a suspended license and whether that's a valid license or whether he's still someone that holds a license. But to say that he merely had his practicing privileges suspended is not supported by the language that you want us to look at so closely. It's the license stuff.
Mr. White, go ahead and answer Judge Atkinson's concern, and then you're into your rebuttal time, okay?
Thank you. I'm going to have to just take it back that there is a distinction between a suspension and a revocation. A revocation is a withdrawal of a license.
Yeah,
A suspension,
okay, so the distinction between a suspension and revocation, and so you're conceding that the license was suspended. You're just saying
of course,
that only a revocation is what can make him no longer a valid license holder.
for the limited purposes of the exemption to the ACA requirement of having a medical director. I only propose this. He is still 100% owner as a licensed physician of his medical facility, thereby making the medical facility exempt under 627-736 from the requirement of clinic registration and the attaining of the hiring of a medical director. Thank you.
Thank you, Mr. White. Ms. McLemore.
Hello, Your Honors. May it please the court. My name is Deanne McLemore and I represent Progressive Select Insurance Company in this matter, and we are asking this court to affirm the judgment. As I think this court understands, this case really simply boils down to one single dispositive issue, and that's whether Dr. Muto was licensed to practice medicine as a chiropractic physician under the PIP statute, as well as the healthcare licensing laws for which the PIP statute incorporates. And so the answer to that simply turns on the plain language of the definitions. And so the definition under the healthcare licensing laws is a physician is a person currently licensed to practice medicine, chiropractic under Chapter 460. Even looking at Chapter 460, the definition of a physician, chiropractic physician, is any person licensed to practice chiropractic medicine under the chapter. From the plain language of this text, a physician is defined as someone who can currently and actually practice medicine. Mr. Muto can't. It's undisputed. He couldn't. He was prohibited from practicing medicine, practicing chiropractic medicine in the state of Florida after the issuance of the emergency suspension order. He thus no longer fit into that definition of chiropractic physician, which allowed his clinic to get the exemption of the licensing laws. He got the exemption based on him being a licensed physician. That change occurred when he got the emergency suspension order. He got taken out of that definition and he had to comply then. He was brought back into the purview of the clinic licensing laws and he had to comply with them, which included getting a license and hiring a medical director. He didn't do any of that. And under the PIP statute, because he didn't, his bills are unlawful and non-compensable, and neither Progressive's insured, Mr. Boykins, or Progressive under the PIP statute is required to pay unlawful bills. Now, I know there was a lot talking about due process, but while this isn't a matter of law, it would have been easy for him to comply with this statute to do it the right way. And he could have just referred his patients out to the chiro that came in. He practiced right next door. Or he could have simply hired that medical director. Now, I understand that the healthcare licensing laws are strict and it takes time to hire people, but inconvenience in following the law doesn't give you an excuse for not following that law. We still have to follow the law, and he took a shortcut here. And you don't get paid for taking shortcuts under the clinic licensing laws or the PIP statute. So while he may have his license was suspended under the definition, that means he was not licensed to practice medicine. he is not able to seek PIP reimbursements for these charges in these cases. And Judge Lucas, I did want to answer your one question you posed about the lawyer that gets suspended. This is the same situation here, very similar to a lawyer that gets suspended. Once a lawyer gets an emergency suspension order, that lawyer cannot tell people that he or she is a lawyer, nor, more importantly, can they manage their law firm. They have to shut it down. They are not allowed to practice law in any way, shape, or form, including managing their law firm. Same situation here. When he got the emergency suspension order, he was required to temporarily cease his operations, either refer your patients out or temporarily cease your operations so you can comply with the healthcare licensing laws as the PIP statute and Florida Department of Health requires. And he didn't do that here. So he had a suspended license. He wasn't licensed to practice at this time, and his bills were unlawful and non-compensable. And we think this court should affirm the trial judge's correct ruling and correct interpretation of the plain language of those definitions. And quickly, appellant keeps talking about chapter 458. Plaintiff never brought that up under below to the court. There's nothing in this record that talks about chapter 458. However, if you even want to look at it, it's the same definition that a licensed physician is one that is able to practice medicine. And again, he doesn't fit that definition either, even though they never brought that up below. And further, I just want to bring up one point that they brought up in their reply brief about their claim for relief here that we never got a chance to address because it wasn't brought up in the initial brief. And that is they were asking the court to reverse and enter a judgment in their favor. And I just want to make it clear to the court that that would be inappropriate. If this court does decide to reverse, it would be for a remand for them to go litigate their PIP case. They still have to litigate their PIP case on the merits, reasonableness, relatedness, and medical necessity. So they don't get a judgment in their favor here upon reversal. But we think that this court should affirm the judgment because the court made a correct interpretation under the law of these definitions. And it sounds like the court understands these laws. So does anybody have any questions? If not, I will cease the rest of my time.
Thank you, Ms. McLemore. Mr. White.
Thank you all. Thank you, counsel. Counsel's correct. This would be remanded for further proceedings. Thank you. The crux of counsel's argument, I think, supports our position. The words she used at the beginning of her argument, currently and actively able to practice medicine, those words are nowhere in any of the definitions that we read. That is an assumption, an inference made. But I can promise you, those aren't big words the legislature could not have determined to utilize had it seen fit. When you look at the definitions pursuant to the administrative code we've talked about, 59A-33.001, right under physician, we have what an unencumbered license. It means a license issued by a respective health practitioner board of the Department of Health that permits a physician to perform all duties authorized under a license without restriction. If the legislature had intended in the PIP statute, in the definition statutes, in the administrative codes, to incorporate unencumbered associated with a licensed physician, it very well could have. What appellee does, what the lower court did, and what we're not able to do under Florida law is add language to these statutes to make them fit our perception. I'm going to offer this. It is unpalatable. It's not very easily digestible that Dr. Muto with a suspended license can still own his medical facility. But that is the law as written. There is a distinction between unencumbered and the definition that is utilized as it relates to chiropractic physician, physician, and physician under the administrative code. We can't just take our words and say physician means a person currently able to administer care, because it doesn't say that. Somebody who's currently licensed, currently means now, not yesterday, not prospectively. Are they currently licensed? Dr. Muto at the Times, Alma Times material here too, according to the chiropractic board, was licensed, had a valid license. He was a licensee, referred to as such by the chiropractic board. The Florida Board of Medicine, even as it defines emergency suspension, still refers to the individual as a practitioner, a licensee, etc. And specifically, the Florida Board of Medicine and the portion that I'm talking about, The licensed practitioner is suspended by emergency order of the department. Licensee may not practice in Florida while license is suspended under emergency order. The practitioner is obligated to update his or her profile data. These words are being utilized because they have the correct and specific meaning to this very unique situation. I do not offer that Dr.
Mr. White, you'll
Muto,
need to wrap it up, sir.
that Dr. Muto could practice medicine. But when you go through a strict interpretation, as is required, to the plain and clear meaning of these statutes, you can only come up with one conclusion, that under Florida law, he remained a licensed physician. Again, Your Honor, and most importantly, take it from the chiropractic board who was overseeing his license. Please understand that ACA's remedy for a medical facility operating without a medical director is an emergency suspension of that clinic's license, neither of which happened
Thank you,
in this
sir.
case. Thank you.
All right, thank you
Appreciate
both.
your
At this time, we're going to transition to our 11 o'clock docket. Before we do that, though, we will take a short recess of 10 minutes. We'll circle back here.